After the 2015 victory in the Court of Appeals, a calm settled over the camp. For 9 long years, residents lived their lives and raised their families, believing the war in Camp John Hay was over. But the BCDA never really put down their weapons. They just waited for a ruling that would shatter the peace. The BCDA had gone to the Supreme Court to challenge the protection the Court of Appeals had granted to the Camp John Hay residents. On April 3, 2024, the Supreme Court issued a decision, granting the BCDA's petition. The court reversed and set aside the Court of Appeals ruling. They reinstated the 2015 order of the Regional Trial Court. This meant the writ of execution and the notice to vacate were back in full force. The court ruled that CJH DevCo must vacate the premises. However, the High Court also affirmed that the BCDA was still obligated to refund the 1.42 billion pesos. The eviction of the developer was conditional on this payment. But here is where the situation gets dangerous. The BCDA read this decision and immediately moved to clear the entire camp. They argued that because the writ was reinstated, everyone had to go. But this interpretation deliberately ignores a massive legal distinction. Inside Camp John Hay, there are 2 very different groups of people. First, there are sublessees, businesses renting space for commercial operations. Second, there are third parties, investors and families who actually bought property rights and own their units. To the BCDA, these 2 groups are the same. They label everyone as persons claiming rights under the developer. But legally, a shop paying monthly rent is not the same as a family who invested their life savings to buy a home. By treating them as the same, the BCDA is trying to use a generic eviction order against the developer to seize private property rights from people who were never part of the original dispute. But the BCDA is ignoring the most critical part of the ruling. While the court ordered the developer to leave, they explicitly stated that the rights of the third parties remained unadjudicated, which means undecided. The Supreme Court did not say the homeowners were illegal. They did not say they lost their rights. These third parties still have the right to sue or have their day in court to prove their ownership. Their rights were not taken away. Yet, the BCDA continues to assert the opposite. They act as if unadjudicated means guilty, treating the silence of the court as permission to evict everyone without a hearing. The Supreme Court left the door open for the innocent to defend themselves. But the BCDA is trying to slam that door shut before anyone can walk through it. The ruling was meant to end a partnership, not to bypass the constitutional rights of the families who call Camp John Hay home.